The second ethical violation, in my opinion, is related to the Code of Conduct Agreement that was executed between Highbridge Wind LLC and the New York State Attorney General's office. The Code of Conduct Agreement was entered into between Highbridge Wind LLC and the New York State Attorney General's office on May 30th of 2018. So that's approximately 2 weeks after Linda Seneck signed the memorandum of lease and easement agreement with Highbridge Wind LLC. So that was very well known that there was public disclosure that was required with the Code of Conduct Agreement. And that's why it forms the basis of the complaint that I filed. This is an actual copy of the complaint filed with the Attorney General's office. It was filed with Judith Malkin. This is dated July 23rd of 2020, so this was last week. So in Section 2 of the Code of Conduct Agreement, it states, for any financial interest held by a municipal officer or his or her relative in any property identified in the wind company's wind farm development prior to execution of the Code of Conduct Agreement, the wind company shall disclose the full name of the municipal officer or his or her relative and the nature and scope of the financial interest. So it's a record which has been filed with the Shenango County Clerk's Office. There's a record of the memorandum of lease and easement agreement being filed in the county clerk's office. Linda Seneck signed that lease agreement 2 weeks prior to Highbridge Wind LLC entering into the Code of Conduct Agreement with New York State. Highbridge Wind LLC knew full and well that there was a conflict here, and that was something that's required to be publicly disclosed. If you look at the definition section of the Code of Conduct Agreement, so that is in Section 5, a relative is defined as including siblings when the wind project is being reviewed as an Article 10, which in the case of the Highbridge Wind Project, it's being reviewed as an Article 10. So that's the nexus, is you have a project that meets the threshold of how it's being reviewed through the Article 10. For Article 10 projects, a sibling is defined as a relative. The Code of Conduct Agreement requires public disclosure, and they have to post that disclosure notice on the project webpage. So if you download the disclosure notice that's on their webpage, Teresa Marks is the only municipal officer being identified as part of that public disclosure. That was last updated on August 8th of 2019, so about 15 months after the fact of when the Code of Conduct Agreement was executed. So there was 15 months for Highbridge Wind LLC to update that list, but they didn't, because I think it was clear. They did not want the state to know, in my opinion, of the potential conflict of interest of the town supervisor having an indirect financial interest in the project. In my opinion, Highbridge Wind LLC, Calpine Corporation, needed George Seneck in the position that he was to captain the ship through this process, to steamroll this project through the process. So that formed the basis of my complaint with the Attorney General's office, is the fact that the disclosure of George Seneck and his brother Peter Seneck having a financial interest in 215 acres of land that was leased to Highbridge Wind LLC. But what really raises red flags to me, when you look at the easement maps, the project maps that are all part of the Article 10 proceeding, that 215 acres of land, there's no improvements. There's no new utility lines crossing that property or going under the property. There's no access roads to any of the wind turbine locations. There's no wind turbines located on that 214 acres. So what is the purpose in Linda Albright Seneck signing that lease? You've got 215 acres of land that were leased, from what I've seen as part of all the public documents. Nothing as part of the High Bridge Wind Project is happening on their acreage. So that's either very bad financial planning, which I'm having a hard time believing that a multi-billion-dollar company like Calpine would mismanage a lease agreement to that magnitude, or this was done to curry favor from George Seneck to steamroll this project through the process. In my opinion, that's what happened here. And I think people need to realize that this is not an isolated incident that not only wind companies use, but if you look at what gas companies did as part of their leasing, I mean, there's a lot of corruption that goes on here. And in my opinion, this is what happened. This is just another standard operating procedure for a big corporate entity to come into a very rural area that has absolutely no zoning ordinances whatsoever. You throw a little money around. From what I've seen, and I think for the little bit of information that I provided in part 1, and now that I've provided in part 2, there's a lot of questions that need to be asked. In part 4 of the series, I'm going to get into the details of the intervenor funds contract that was executed between George Seneck and the state, what I believe to be a conflict of interest regarding that contract related to Article 18 of the General Municipal Law.